inaugural and a very, very proud event of Privacy Hub Africa. Before we get started, I just want to share with you some requests to make this session go very well for all of us. As Solomon provided, that the sessions are being recorded. The recordings will be kept in accordance with the PHA's retention practices. Your display name, image, and any comments or questions, your input into the session will be part of the recording. Please note that you may ask questions anonymously, and if we have such facility on Zoom, please use it. We would love to see you when you ask questions or make comments. It's not compulsory, but at that point, please switch on your camera if you do not have any objection to your image being recorded. Your voice will also form part of the recording. So if you do not want that retained, kindly provide or ask your questions and comments in the chat facility. The recording will be shared with delegates once the course is over. It's a 3-day course from today, 23 to 25 March, in 25 January, in commemoration of International Data Privacy Day. The recording will also be available on our YouTube channel, and it would be available on the website, but there's some work being done on the website, but that work should be contributed shortly. Just some rules, please. Please keep your cameras off. We appreciate the 6-packs and the roofs, but please can you keep your camera off and your mic off during the session. Please, as I said earlier, switch it on once you are speaking. All questions and comments will be acceptable in the Q&A chat box. Please write in full words and sentences. Some of us are way past the digital short notes. All members of IAPP can claim CPE points for this 3-day workshop. We will provide you with a link in case you don't know where to find it to submit on the IAPP's website. All attendees will receive certificates, attendance certificates on completion of this session or this masterclass. And these certificates will be issued to those attendees who attended all the classes and all 3 days. At this point, I'm not aware of any exceptions, but being realistic, please do not hesitate to let us know if for some reason beyond your control, you were not able to join us in 1 or 2 sessions. Please may I hand over to Dr. Nkwanko, who is going to speak to us and introduce TechForGood Initiative. TechForGood Initiative is also a co-sponsor and planner of this event. Dr. Nkwanko, over to you, and thank you.
Thank you very much, and I'm happy to introduce TechForGood Initiative. Is a civil society organization that is formed specifically to harness the power of technology for development in Africa. This is more or less our first initiative, and we are happy to continue partnering with Privacy Hub Africa and others to make sure that the fruits of technology trickles down to every household in Africa. Thank you. I yield the floor back to you.
So without further ado, we're going to start the course, the reason we are all here. I would like to introduce our next speaker. This speaker is well known throughout the industry, and she's going to speak to us about the introduction to data privacy in Africa, specifically focusing on the understanding of the current data protection landscape, including regional regulations and instruments like the Malabo Convention and some country-specific laws. Dr. Mugambi Laibucha is a distinguished advocate of the High Court of Kenya. He's a certified information privacy manager as designated by the IAPP, which is the International Association of Privacy Professionals. He's a trained mediator and a renowned expert in privacy and data protection. With over 15 years of legal practice, he has established himself as a leading authority in digital rights, legislative drafting, and governance. Dr. Laibuta earned his PhD at the University of Witwatersrand, right here in our country, where his groundbreaking research focused on privacy and data protection in Kenya, contributing significantly to evolving this field. As a consultant and advisor, he specializes in policy development, rule of law, constitutionalism, internet, and technology law, as well as data protection governance. Dr. Laibuta also serves as a faculty member of the Kenya School of Law, teaching legal writing and legislative drafting to the next generation of legal professionals. He's currently the chairperson of the Data Privacy and Governance Society of Kenya, further demonstrating his commitment to advancing data privacy standards and governance across the region. Dr. Laibuta's extensive experience in thought leadership make him a pivotal voice in Africa's data protection landscape, and he's also a well sought after speaker. Dr. Laibuta, may I hand over to you. Mambo.
Very Sana, thank you so much for the introduction. Allow me to share my screen. You just let me know when it comes through.
We do see the intention. Please do not give up.
Yeah, you have. Is my screen visible?
It's visible. If you
Yes,
could just put it down
yes.
to presentation mode, please go ahead. Thank you.
Okay. Thank you so much. Thank you, everyone. So I'm going to. Mine is basically an introduction to the masterclass, and I'm going to talk about. It's not a lecture. I wish to raise a few questions that, as data protection or privacy practitioners within the continent, we need to think about. Because one of the biggest challenges that has been there for practitioners is the question. Oh, okay. Right. Yep. All right. So I have there's this list of around 40 African countries that have some measure of data protection laws. And one of the interesting thing as a researcher, if you carry out some research, you find out there are not two laws within the African continent that are the same. So if you pick up an act, let's say you pick up the Mali Act, you pick up the Niger Act, the Kenyan Act, you'll find that it's they're all different. They may have some similarities. They may have some basics that I'll talk about, but not two laws. You can say a copy or paste or a similar. And this is when you compare to, I think within this part of the world, we'll have to compare with the GDPR. And we state that, you see, in Europe, all countries that are within the European Union are bound by the text of the GDPR. So there's a sense of uniformity. And this uniformity allows you, for example, if you're a practitioner, if you're in France, you move, for example, to Spain, you know that you're dealing with the same standards, but it's not the same in our region here, and in some of the questions that we need to respond to. And as we think about this, we've had the African Union Convention on Cybersecurity and Personal Data Protection. So this convention, I think it was hailed as groundbreaking, but some of the questions that I usually ask myself, one, when you compare, for example, to the GDPR, and you'll allow me to make that comparison to the GDPR is binding to all EU countries within the European Union. And there's a mechanism to enforce it. We have the European Data Protection Supervisor, we have the board. I mean, simply, there are mechanisms that they can collectively use that are stated within the text of the document on how the text is supposed to be implemented, is supposed to be effected, is supposed to be monitored, etc. But then when you look at our convention, one of the biggest questions, not just with the Malabo Convention, with the African Union Convention on Cybersecurity and Personal Data Protection, that is called the Malabo Convention. one of the questions is that African Union laws, to what extent are they binding to member states? What happens if a member state does not implement it? So then what happens? So some of the questions that we need to pay attention to. Then it was adopted in 2014, became operational more than almost 10 years later, 9 or 10 years later, and it's been ratified by only 16 countries. The last I checked, only 16 countries have ratified it. So the question also begs, where are the other African countries? Do they not want to be part of this? For example, my country, Kenya, was at the forefront of the discussion of the text. But up to date, Kenya has not signed, has not ratified this convention, in as much as we have a Data Protection Act. So the question arises, is it an issue of a lack of political goodwill, or is the text problematic? Because as it stands, there have been efforts, I think, in the last 2 years to amend provisions, to revise or to improve this convention. And then I'll talk about how that now goes about with the digital trade protocol, because it seems that there are many initiatives that are going around dealing with issues of data protection. So as I said, Kenya, we've not ratified it. And the most interesting thing is that Kenya has not ratified it, but in our regulations, one of the methods to indicate or to find that a country has adequate data protection framework is that they must have ratified the African Union Convention. Then the question I usually ask myself, if we as Kenyans were saying that is a way to determine adequacy, why aren't we ourselves ratifying it? But be as it may, the convention also provides some basics. So one of the questions that academics ask is that does the convention reflect what we as Africans determine as the baseline or the basic framework of data protection, despite some of the gaps that are in this text? Something else that's practitioners, academics, we need to think about. But you look at the principles that are there under the convention. They are principles that we all know about. They feature in our legal text, in our data protection and privacy laws. The issues of consent and legitimate processing of data, the issue of lawfulness and fairness, purpose, relevance, storage, the issues of storage limitation, the need for accuracy, the need for transparency of personal data processing, confidentiality, and the security of personal data. You find, for example, if you look at the Kenyan Data Protection Act, which I'll refer to from time to time, is that we don't have this principle of security of personal data does not feature in our text. Also, the Malabo Convention on the issue of accountability. In my research, I usually feel that it's very important to explicitly state some of these principles. Because, for example, if your text does not explicitly state the principle of accountability, doesn't explicitly state the principle of security of personal data, then it may be arguable. People may use a lot of time just to argue that so long as it's not stated, especially lawyers in the room, they'll want to argue if it's not stated, it means that it ought not to be provided for. But essentially, the Malabo Convention provides these principles that countries within our region may borrow from. Of course, it identifies sensitive data. The convention prohibits the collection and processing of sensitive data, racial, ethnic, regional, political opinions, religious, philosophical beliefs, trade union membership, sex life, and genetic or health information. You'll find that in some statutes within the continent, they are not as comprehensive as this. For you'll find that there are countries like my country, they'll not have the issue of political opinions is not stated as sensitive personal data. Trade union membership is not stated as personal data. Then on the issue of sex life, like for example, our law goes further and talks about sexual orientation. I mean, borrowing from the GDPR. I usually say it's within African context and understanding how gender is perceived, it's always curious to me that our Data Protection Act features sexual orientation as sensitive personal data. While you look at litigation in the courts, people really fight that aspect. And other statutes, the statutes that I've looked at, data protection statutes, they only talk about gender. They don't expand what this sex life, what gender is all about. So the question is, what is it? What as Africans would we consider as sensitive data? And of course, political opinions and trade union membership are sensitive because we realize not every state within the African continent are within a constitutional democracy framework. Some of those frameworks are either there or are not being implemented. Then the convention also talks about sensitive data exemptions, that you can process personal data if it's made public by the data subject themselves with the consent of the data subject, when processing is necessary to protect the vital interest of the data subject, for legal claims, public interest, scientific research, for performance of a contract, and to comply with legal or regulatory obligations. One of the challenges is that I think with this, what I can say, and not just the Malabo Convention, is consent. I think consent as practitioners is sorry, I think somebody's saying you can't. Can you hear me, guys? I think Naomi says they can't hear me on the presentation.
Doctor, it's very loud and clear on my
We
side.
can hear you. It is clear. Okay. Thank you for.
I can hear you. It's clear.
If your camera is off.
Right.
Oh no, that's a very nice steering wheel.
Okay, just let me know if there are any challenges. Okay. Yeah, so there are those sensitive data exceptions. Then the convention also talks about, it has a list of data subject rights: right to information, right of access, right to object, right to rectification or erasure. The gap, of course, one of the gaps is the issue, the right to make a complaint. I usually believe that it's important for a statute to provide the issue of access to an effective remedy. I think it's also silent on the issue of automated decision making. So I think this process, though I'm not privy to the process of improving the Malabo Convention, should also be live to the technological advancement. So how will it deal with issues of automated decision making, for example, the right to representation? I think it's usually sometimes in some jurisdictions, if you don't explicitly say that somebody who's making a complaint, who's having or filing a suit, though constitution say it, but some say if you're not, it doesn't say that you have a right to representation, then it becomes a challenge. I think it's also silent on the issue of processing of personal data for certain interest groups, for example, like children, elderly, or people who need really that kind of representation, and it's something that perhaps requires improvement. But also it talks about the obligations of data controllers, the issues of confidentiality, security, storage, and sustainable use of personal data. Then it says that each party is required to establish an independent national authority responsible for the protection of personal data. But if we look at this is a debate. I think I made it at I made at a conference, and I think some countries were not happy because they strongly believe that their statutes really provide an independent authority. Like, for example, I can confidently say when we analyze, of course, the Kenya Office of the Data Protection Commissioner has been acting independently, but when you look at the text of the law, there's a role of the minister or the cabinet secretary in charge of information, communication, and technology. The data commissioner in Kenya does not report directly, according to how the act is couched. When they're making reports, they make the reports to the cabinet secretary or the minister, and the minister makes that report to parliament. If you look at certain countries, the regulator is under a department of a ministry. So the question is, the question is, being within that being within a department of a ministry, does that make that person independent? A question that we need to ask ourselves. The issues of financial independence, administrative independence, independence in the decision making, because we have all this, we have political, financial, social, religious interests that may have an effect of how this regulator may decide. Then the question is, what if a country has a law and doesn't appoint a regulator? What happens? I think this is one of the gaps that I say is there within this convention. It doesn't say what happens if if a state party does not establish this independent authority and doesn't break down what do you mean by independent authority. I think it's something that we really need to talk about. To talk about. Then something else that it talks about is cross-border data transfers. It says that a data controller cannot transfer personal data to a member state of the African Union unless there are adequate protection. Just give me a moment. I think my internet is flat. Just give me a moment. I change this connection. One moment.
Please, participants, engage with
I think
our social media platforms while we're waiting for Dr. Mugambi. We can provide feedback on LinkedIn, etc. I think it's they've been put in the chat. Dr. Mugambi, are you back?
Yes, it was showing me low. I mean, it was showing me that it's not stable. Can you hear me? Okay.
We've been hearing you just fine.
Okay, sorry, I just didn't want to disappear from the screen. Okay, so there's that issue of cross-border data transfers, and I think we'll speak about this in the when we talk about the regulations, the digital protocol. What really does it mean when you say a data controller cannot transfer data to a non-member state of the African Union unless it ensures adequacy? And then this issue of adequacy, how do we determine adequacy? I think the GDPR has some sort of measures. It gives a list of what we need to use to determine adequacy. I think there was a matter that had been filed in the Nigerian High Court relating, I think, to a list when the regulator was a directorate, and they provided a white list, and that white list was challenged. How it came about. At some point, Botswana also had come. I think the minister had come up with a white list. But the question is always how do we determine adequacy? And I'm passionate about adequacy because it's something that I wrote in my PhD research was specifically on determination of adequacy, because I think we need a method to it. Of course, when you compare with the EU and giving adequacy to other countries, it's also a political. We need to also to understand that it's a political process in as much as it's a legal process. But I think as practitioners, we really need clarity on how do we really determine whether Botswana, whether Nigeria, or whether Mauritius are provide adequate protections. Then something else that we need to think about is the regional data protection laws. For example, ECOWAS, we have this the Act on Personal Data Protection within ECOWAS, and from my research is that the ECOWAS the Act is under review. I've not seen the text of the review to see what is it that is being proposed to be amended, but I think it's something to think about. We have the Malabo Convention, we have these regional laws, we have the local laws. So how does it work? Of course, SADC has a model law on personal data protection. My EAC, where I come from, there was a proposal many years ago to come up with a law relating to personal data protection, but that did not happen. Then what happens to other regions? So we need to decide how do we go about it? Do we have regional laws? Do we have the Malabo Convention? What will rank above the other? What will guide the other? Because of course these ones are they when you look at the text is all different. So if you put out the SADC model law, the ECOWAS Act, and the Malabo Convention, all totally different. And even if you pick any act, even if you pick the Nigerian Act and you juxtapose it with the ECOWAS, they're not the same. So questions to think about. We really need the Malabo Convention, then of course the regional laws, then we have the local laws. It's something to ponder about. Then allow me to talk about something that is a bit that has elicited a lot of debate: the Digital Trade Protocol to the agreement establishing the African Continental Free Trade Area. Because the digital protocol, and we remember why I say it has elicited a lot of debate, is that even when this text was being passed by the ministers at the AU, practitioners were not sure about the text. Some people said, we know what the text looked like. Some people say, we are not sure. Those are texts that had been leaked. So the question is, how do we as practitioners engage in that process? Because there are very critical aspects of this process that will affect our practice, especially when we are talking about cross-border data transfer. Remember, the Malabo Protocol say don't transfer data outside member states who are not compliant. But then the question is, what do you mean by compliance? We have really not we have really not spelled out what adequacy is. But the digital protocol provides certain things that are certain items that are critical for us to ponder about as practitioners. One of it says that state parties, there's an annex. So the annexures, the juice of this protocol is in the annexures. The process of coming up with the annexures has commenced. The AU has commenced that process. So one of the questions is, within our spaces, how do we plug into that process? Because it says, for cross-border transfers, that there'll be an annex that will talk about cross-border transfers to allow cross-border of data, including personal data, by electronic means, by state parties, that the annex shall also set out how data is to be used, restrictions on data sharing, including data protection regulations and restrictions that may be applied. So one of the things that I think perhaps the Digital Trade Protocol could do is bring all of us within the African continent together and say, hey, these are the standards that all laws, if you are having data protection laws, data protection regulation, perhaps this is the yardstick. This is the bare minimum. But then we also need to answer, how will the Malabo Convention and these annexes within this digital protocol speak to each other? What will rank higher than the other? Which is, of course, trade law experts will say that, the trade protocols usually are more binding. If you compare the trade protocol and the Malabo Convention, ideally it is the digital trade protocol that should be binding to all states. So then will it provide a model act, for example, that all countries should fashion their laws in this way, or will it go to the GDPR's way and say, this is the standard that all African countries are going to use? Then when you go to the issues of personal data protection, it says each state party should adopt a legal framework for protection of personal data and especially engage in digital trade. So here's where I'm saying, in these annexes, do we create a text and say, this is the text that we are all going to use? And what if one of the countries or some countries don't sign into this digital protocol? You get the confusion. So it basically moves back to the political questions. Our politicians, what is it that they want? And as we are thinking about what do our politicians want in terms of this text, we also have to think about the effect, what I usually call the elephant in the room, which usually elicits very uncomfortable conversations. The economic, the political, the social, the religious interests that come into these spaces when we are discussing issues of data protection, when it's discussing issues, data protection, regulation, and compliance. How do we deal with them? And some of these interests are interests that are from within the continent, some are interests that are from outside the continent. And it becomes a dicey affair. And of course, our politicians never speak with one voice on these issues. Then it says state parties must take into account relevant regional, continental, international guidelines when developing digital trade frameworks. So the question is which ones? Because is it the Malabo? Is it the ECOWAS? Is it the SADC? Another question then. State parties are required to public information about laws on personal data protection. I think, by and large, at least on many African countries, you can find the text of the data protection laws. One of the challenges is usually the subsidiary legislation or the regulations that you may not find. Then it talks about enterprises within the state party territories are required to adopt and maintain policies and procedures to protect personal data. Here, I think the protocol in the annexes could go further and give a list or I don't know, maybe we'll have that discussion. Give a checklist or where we can say, if you are operating within Africa, processing personal data, this is your checklist. This is what, because just saying maintain policies and procedures, it's a bit vague. And as practitioner, you know, sometimes you go work for a client and a client says, we have a data protection policy. I think that's enough, but it's never enough. There are a lot of things that you need to do in terms of data protection compliance. Then it says state parties should develop mechanisms to enable natural persons to exercise their rights. So the questions, some countries, like for example, look at Kenya, you look at Tanzania, you look at Uganda, you look at South Africa, there's a regulator in place where you can go and make a complaint. And the appeal is usually to the High Court. But you see also our legal system is not uniform. And when you look at our Data Protection Act, the decisions the regulators can make are not similar. Some, for example, when you look at the Nigerian Act, I think it's a bit more progressive on some of the decisions that the regulator may carry out. But then the issues of locus standi, I mean, the standing, I'm trying. Locus standi in simpler terms. Sorry, guys, I'm thinking as a lawyer. Apology. Anyway, the right for you and I to go to make that complaint or go to court, it's always it's a question. So when you say develop mechanisms to allow natural persons, what about people who are not natural person? Natural person is human beings. What about corporations or entities? For example, in South Africa, there's a court decision that says that there's protection of corporations or legal entities, but they are to be determined from a case-by-case basis. It's something that we need to think about within our continent. Then he talks about state parties are required to establish national data protection authorities. The same with the Malabo Convention. What do we say? What will it talk about the issue of independence? How will it determine that the union is independent? So a checklist, what does it mean to be independent? I think the GDPR is a bit comprehensive by talking about the issue of independence. For example, politicians can come and change the law. Is that something that needs to be allowed? The European courts have said, no. You can't just come and amend the law and want to remove your data protection commissioner or authority. Then state parties agree to cooperate on issues of personal data protection, cross-border data transfer, online consumer protection. So many questions. As you see, I'm just raising questions because these are things that as a practitioner and as an academic, I identify, and I'm like, how do we implement this? How do we move? And how do we make it compulsory and have checklists that are binding to data controllers, to data processors, to these authorities? How do we provide for effective remedies? Because one of the challenges that especially I think the discussion has been in Kenya and also in the EU is that a regulator may make a decision, but how do you enforce that decision? See, it's a challenge. How do you enforce the decision? So going back, the digital trade protocol talks about that state parties are to adopt this annexes on cross-border digital payments, cross-border data transfers, criteria for determining the legitimate public reasons for disclosure of source of data, issues of digital identities, financial technology, emerging and advanced technology, online safety and security. In my view, there ought to have been, as I said, with these annexes, a baseline text of a law that should apply in personal data protection within the African continent. Whether that will be the Malabo, they can say it's the Malabo Convention, whether they say that there'll be a model law, because really this doesn't answer to the questions that practitioners face face out there. Then we also have the AU data policy framework. As you see, we have many frameworks, and the policy framework is supposed to be persuasive. There is, it's really not binding in the strict sense. And what it aims to do is to guide us in developed African countries to develop the national data systems and capabilities, provide a comprehensive approach to data protection, emphasizing the need for trustworthy and enabling the data-driven development in Africa. And its guiding principles are things like trust, safety, and accountability, fairness and inclusiveness, the need to categorize data. So one of the challenges, especially when you find it, is that especially when you're in an environment where you're actually handling data, is the issue of data protection and data governance. Of course, we know they are really not the same. So because we are not always dealing with personal data, essentially, a data handler handles both personal and non-personal data. And sometimes it's important to have a framework that speaks to each other on these two things. So issues of data categorization, you'll find that this is within data governance. And within data protection statutes, it doesn't talk about the issue of categorization. Of course, talks about legal and institutional framework, data processing principles, the right of data subjects, cross-border data flows, that they should be allowed, the issue of data justice. And data justice here, we're looking at issues of human dignity, inclusiveness, because we know within the African continent, there are many marginalized groups. And there are groups that are facing serious threat to their lives, even just because of the data. If you're able to be identified with your data from coming to this or that persuasion, then your life is in danger, or you become even further marginalized. Then cybersecurity. So the question of the interplay between personal data protection, data governance, digital trade. How does that come in? Then issues of ethics by design. How do you design? Then the question is, should we have? Is the law really the way to go, or do we need soft law? Because a lot of countries, especially in Africa, when we are thinking about regulation of AI, you've seen a lot of them. Even in Kenya, I think there was a draft in South Africa. It's a strategy or a policy. People are shying away from having regulations like the European Union AI Act. So is that the way to go? Ethics, do we really follow the ethic? Do we need ethical guidelines? How do we balance competing competing interests? And this interest could be, as I said, political, economic, social, religious, tribal, etc., and the need for harmonization. So the elephant in the room always, harmonization. How do we harmonize? When you listen to our regulators, they're always pushing for harmonization. But when you look at the African Union hierarchy, one of the questions that I always ask, where do our data commissioners? They are doing fantastic work in terms of pushing for the conversation on normalization. But are they decision makers within the African Union hierarchy of making laws? And the answer is basically no. There's somebody above them. There's the minister, there's the head of state, there's the head of government. So in my view, there seems to be a glass ceiling that they are facing. But one of the best things they could do is come up with a text. They can come up with a text, they can say, because under NADPA, the Association of Data Protection Regulators, and say this is the text that we wish to apply to regulate ourselves. But just a thought. So the challenges here is that as you're seeing within the African continent is the establishment of data protection authorities is an issue. The issue of harmonization of legislation is a big issue. The ensuring compliance and enforcement within a region. If it's a company, I mean, especially telcos and banks within the region, they operate within more than one state. So one country. So how do you ensure compliance and enforcement? They could be complying in Kenya, but they're not complying in Togo, or they're complying in Mauritius, they're not complying in Zimbabwe. So how do you deal with that? And the GDPR provides a very good mechanism for this, whereby if a data handler operates within a wide region of the EU, there's a mechanism for enforcement. Then the issues of cross-border data transfers, I think it's still a thorny issue. Some countries talk about data residency, some about localization. So the question is, then it becomes a bit different. Like in Kenya, we have certain data that must be, at the very least, must be resident within Kenya, and the others that you can really, it's not compulsory. Then balancing data protection and free flow of information. And when do we say that we really need this free flow of information? Those exceptions, and we really need to define those exceptions, because if you're working, for example, in the Horn of Africa, around here, we have a lot of migratory communities. We have communities that are fleeing from political turmoil, from climate change. So how do we deal with that? The issue of digital infrastructure, when you look at reports, the digital penetration within it's not the same. There are countries that are quite advanced than the others. So, and the question is localized digital infrastructure, data centers, for example, the internet infrastructure. Who creates them? And are all countries the same? Of course not. The issues of digital inclusion, digital literacy here, it's a big issue, because one of the arguments in Kenya has been that data protection compliance is a capital city issue. It's for those people in the cities. Everyone else seems to be ignored. So what the Data Commission has been doing is trying to do these sensitization sessions. But then you see that literacy affects somebody who wants to hand over their data. They may just do it. For example, if it's a chief or it's a police or local administration who demand it. So digital literacy, digital inclusion, that infrastructure, the issue of emerging technology, and of course we've heard of the terms of digital colonialism, algorithmic colonialism. Are we able to create local technology? Because the argument by many people is that we are net importers of this emerging technology. When will we be net exporters of this technology? Then, of course, the issue of resource constraints, and resource constraints deal with all these issues that we are talking about here. The issues of political will, the fact that our regulators have some sort of glass ceiling when they're thinking about harmonization. They're not able to sit at the table of the AU and make the decision to pass these laws because it's the ministers, it's the heads of states, it's the head of government that do this. The issue of coordination and cooperation, the fact that our laws all look different shows that coordination and cooperation is an issue. And lastly, of course, what constitutes adequate protection? If we can answer this for us as Africans, what will we say? This is what constitutes adequate protection. Thank you so much for listening to me. Of course, I'll share the slides, and I welcome questions and discussion.
Thank you so much, Doc. That was a very, very informative and lively presentation. There's quite a lot that you said in that. Just tip of the iceberg is that the lack of uniformity of laws in Africa. And this, for me, is preventing us from growing and becoming basically the giant that we could be. And the AU basically not enforcing the Malabo Convention properly at all is one of the contributors. You said there's some work that's been done there. Do you see any possibility of the AU becoming the European Council or Commission in the manner that they regulate GDPR, just to enable also the AfCFTA?
No, I don't. I don't think so. A lot of my colleagues say I'm always the pessimist in the room, but it's really not pessimism. It's just the realities about how the AU crafts its laws. Even just leave the AU, when you look at ECOWAS, SADC, the East African Community, how laws are made. And now we are thinking about data protection. To what extent, as I said, our data protection authorities want harmonization, but they're not within that hierarchy. they cannot sit in that assembly of states and say this is what they must go through. Their ministers, the ministers at some point must go through the heads of state, and so that is the challenge that we have. And when, of course, the African Union Secretariat is raring to go. If you engage them, they have a lot of support. They're raring to go. They're coming up with these documents, but at the end, how will these documents be implemented? South Africa may pick what the AU is doing, implement it, but what about Kenya? Kenya might say, this is not our priority. And now that brings the issues of the challenges. So maybe not yet, maybe not in our lifetime, but maybe sometime in the future, possibly. Let me be a bit optimistic and say possibly in the future it might be.
Thank you for that. We'll keep soldiering on. I'm going to open the floor to questions. Please have your camera on or put your hand up so that I can identify you. If your camera is off and your hand is up, I will pick you. If none of that, I will not choose, and we'll look for other questions. NK, your camera is on. Esther, Jogi, your camera is on. Are you guys asking questions?
There's something, sorry, I'm trying to look at the chat, and there's something that Merita is saying, that one of the problems is the numerous regulations and laws coming from different institutions. Yeah, so leave even the African Union context. Even, for example, let's look at Kenya. In Kenya, within the banking regulations, there are issues of privacy and confidentiality. In insurance sector, there are issues of privacy and confidentiality. In digital lenders. So then there's really, in as much as we have the Data Protection Act, we also have many other laws that talk about privacy, confidentiality, and the data protection. So even harmonization in country is really a challenge. For example, in Kenya, the Central Bank of Kenya has powers to regulate digital lenders, for example, and the aspects of data protection there. So the question is it primarily the central bank? Is it the data commissioner? And another gap that I forgot to mention is how do regulators come together to deal with that issue? Let's say, for example, you are dealing with a multinational social media platform, and there are issues of, for example, competition issues, their consumer protection issues, and their data protection issues. So you'll find the regulators of these three issues will go and regulate individually. But the question is, how do we harmonize? And the AU data policy framework says that regulators should come together on a specific issues like competition regulators, consumer protection regulators should get away to collaborate when an issue relates to them. But then the question, how do we craft our law to say that these regulators, I don't think there's any law in Africa that says that these regulators can collaborate. So definitely that is a gap.
And, just on that point, this morning I was just speaking to another colleague that here in South Africa, we're having similar issues. Whilst as I mentioned in the chat to another delegate, that a legal entity is also a data subject in South Africa, the legal entities are regulated by other entities as well. So you've got Companies Act, you've got that is being regulated by CIPC. Then you've got the Intellectual Properties Act, you've got etc. Then when it comes to the topic at hand right now, is direct marketing. We've got direct marketing being regulated in our POPIA. We've got direct marketing in the Insurance Act's PPR, the Short-Term Insurance Act. We've got direct marketing in FAITH. We've got direct marketing in ECTA. There's direct marketing in so many laws, implicitly and explicitly, but none of these regulators are speaking to each other. And if we could just get that internal harmonization, I think we would go a long way in the lack of confusion. Because as long as we don't have proper regulation in terms of regulators, we will not comply, because we know this one is going to do this one. Then we go to this one. The information regulator cannot define direct marketing because it's not their area of expertise. We leave that to so-and-so. So when they include telephonic in direct marketing, in electronic communication, are they not acting ultra vires? So there's just so many things that would benefit us as a continent and as a country to harmonize laws. Guys, I can go on and on and on, but this floor is not about me. This floor is about you. Today's about you. Any questions? There are quite a lot of comments in here. If anybody wants to voice them over, please go ahead. If not, I'm going to ask the doctor to close off for us this session of his. Any last comment, advice from for us, Doc?
Yeah, of course, there are colleagues that will talk about the compliance methodologies, etc. But I think one of the challenges that we have is that we have to read so many laws, especially practitioners and academics. Every day there's a new law coming. So you're like, okay, who's passed another law, and trying to make that comparison. But I think one of the best things is that we have a robust group of professionals, and the good thing is collaboration, inter-country collaboration, inter-regional collaboration. So my thing is that when we are talking about these issues, is how can we collaborate? Like, for example, to the annexures to the digital trade protocol, how do we get our voice there? It's something that we need to think about. And of course, I think some of my colleagues will talk about what does compliance mean. But essentially, my parting shot, what does, since I was not talking about compliance, what does adequacy mean? And as I said, I shamelessly plug my PhD thesis where I talk about the issue of adequacy, because it's something that I'm passionate about. How do we determine adequacy in country, and how do we determine adequacy out of the country? I think there's a hand here. I don't know whether it's a question. Myra?
Myra, the floor is yours. We have less than a minute to go. If Myra, you don't take that opportunity, there's another hand up, or it's gone down. Okay, we have many screens. Participants, can I ask if there's anybody who wants to ask a question, please speak up. Just me, and I will give you the floor.
Thank you, Mohale. This is Andrew Mukabana.
Thank you, Andrew. You may have the floor.
Yes, I've shared my question on the chat, but just to repeat, I was asking, if you look at developed countries, especially in Europe, there is a lot of digitalization of the economy as compared to Africa. So we are just catching up on digitalization. And with digitalization comes innovation. With innovation, currently, we are seeing a lot of regulation coming into play, especially in the country. People are being asked to do this and this so that they, look at data privacy issues. How can we balance the increasing complexity when it comes to regulations and the need for inclusivity and innovation in an economy like Kenya, or rather Africa, that is, just coming up? Thanks.
Thank you for that question, Andrew.
Hi.
Let's wait for Doc to answer. Just hold on for us, Myra. Doc?
Okay.
I think there's always that issue of whether regulations are stifling innovation, and potentially they could. And I think that's why for the AI, a lot of countries are moving the policy or the strategy way. But essentially, when you look, one of the questions that I usually ask a client, do you need a law to tell you to protect your systems? If you need a law to protect your systems, then you have a problem. The law is not the problem. You are the problem. So when you look at some of these principles, especially data protection principles, cybersecurity principles, they're for the benefit of your organization. You don't need a law to tell you that. So even when we're innovating, we're just saying, as you innovate, use some basic principles, whether ethical principles. Don't break the law while you're doing it. Of course, there's usually that argument that in the West they developed without any regulations, and that's why they are far ahead. But we've seen that there are harms. I think in Nigeria, for example, there's a text of a bill on social media harms or internet harms. So there are harms to this. So we really need to say, even if we're innovating, what are the basic decent things? Let me not even call them principles. What decency should we apply as we are doing this? But yes, as innovators, the innovators have a big problem when you are dealing with a multiplicity of laws. And I've shared the PDF of my presentation on the chat. You could have a look and download.
Thank you for that, Doc. Mara, can I hand over to you? And one more question, which I will take from the chat. Mara going 3.
Maybe I can say
Mara
something.
2. Myra 1. Okay. Because we need to give the other speakers enough time, there's a question here. It says, as in-house counsel, we fight with a lot of partners across the world when drafting, sharing, and confidentiality agreements, particularly against the governing law. Where is the middle path?
Let me end with a story. Let me end with a story. I hope so. I had 2 clients. One was a tier 1 bank. Tier 1 is like the largest or the highest. Then at the tier 3 bank. Both of them were using the same cloud service provider. So when the Data Protection Act came into place, the tier 1 bank told this cloud service provider that they need to revise the clauses in their service level agreement because we need to make references to the Data Protection Act, etc. So the cloud service provider said they're not going to do that. Then for the tier 3 bank, they say the same. The cloud service provider said they're not going to do that. But 2 weeks later, they came back to the tier 1 bank and begged them to reconsider because they saw the level of business that they are going to lose for refusing to amend their boilerplate contracts to provide for provisions of the Data Protection Act. So with the tier 1 bank, they agreed they are going to amend. For the tier 3 bank, they didn't feel that that business was important enough for them to amend. So the tier 3 bank, I think up to today, just uses the boilerplate the boilerplate clauses. So those are the challenges that you will face depending on your depending on the level of persuasion, on the magnitude or how big your business is. You are able to discuss this with those service providers from outside your jurisdiction. But if you're a smaller business entity, your bargaining power, from my experience, becomes a bit smaller. So I just wanted to answer that question, giving that experience that I had with the tier 1, tier 3 bank on the issue of clauses for cloud service provision and how the cloud service provider dealt with the 2 cases differently.
Thank you for that, Doc. It's a good note to end on. Thank you very much for your presentation. Please do not hesitate to further interact with us in the chat, but we need to move on to the next presenter. Thank you so much, Doc.
Thank you. Thank you for your time.
Okay. Now we're going to go into the legal foundations of data protection. And Olumide Babalola is going to focus on the principles of privacy laws, compliance frameworks, and international standards. Olumide is a distinguished privacy and data protection lawyer from Nigeria, a legal scholar and a PhD researcher at the University of Portsmouth, UK, where his research focuses on privacy jurisprudence within Nigerian courts. With a robust academic background, including a master's in international commercial law from the University of Reading, UK, Olumide is a leading advocate for digital rights and privacy law in Africa. A pioneer in Nigeria's legal landscape, he has litigated landmark privacy and data protection cases, including the 2021 Court of Appeal decision in Digital Rights Lawyers Initiative versus National Identity Management Commission, which defined the relationship between data protection and constitutional privacy rights. His expertise extends internationally as a member of CODATA's International Data Policy Committee and the International Network of Privacy Law Professionals. He's also a lecturer at the University of Manchester, an accomplished author of seminal work in privacy law, including Privacy and Data Protection Law in Nigeria, 2021, Emerging Jurisprudence on Privacy and Data Protection in Nigeria, 2023. His publications have appeared in leading journals like the Computer Law and Security Review, as well as International Data Privacy Law. In addition to his academic contributions, he has co-founded the Privacy Academy, training hundreds of Nigerians in data protection, and the Digital Rights Lawyers Initiative, a civil society organization advancing digital rights through advocacy and litigation. He also convenes PrivCon Nigeria, an annual conference, bringing stakeholders together to discuss privacy and data protection in Africa. His commitment to advancing data privacy is further reflected in his role in leading a 2021 research project on data protection authorities in Africa and co-presenting at the University of Oxford on privacy and technology in Nigeria. As the first Nigerian lawyer to litigate data protection cases up to the Supreme Court and ECOWAS Community Court, he continues to shape privacy law in Nigeria and beyond, serving as a model for legal practitioners across Africa. I know recently he has collaborated with the Nigerian Data Protection Commission to come up with a certificate for data privacy officers in Nigeria. With that, I'd like to hand over to Olamide.
Thank you very much for that elaborate introduction. But let me clarify, I didn't collaborate with the NDPC for the certification. I mean, another agency did that. And I think he's one of these, I think he's not one of the speakers on this, but he's also speaking next week on at an event I'm also speaking at. So without wasting our time, I know many people have spoken ahead of me, and some of the things I'm touching, they would have spoken to it as well. And some of these things are not even particularly new to all of us, but we just have to add this topic to the masterclass. Otherwise, I think it's something that would have been touched by other people. Okay, so this is what I'm speaking to, and I'm just going to do an overview of some principles that, again, some of us already know. I'm going to speak to a little bit of compliance framework, then also some international standards. Well, I'll focus a bit on the GDPR, which shouldn't ordinarily be, because this is an African setting, and we should be speaking much more to our laws, irrespective of how we view them. That's what we have, and that's what we should develop. Data protection has been defined from many perspectives, but basically it's just either the technique or the law or the system or the approach or the mechanism to safeguard personal data from misuse, from compromise, from loss, from unauthorized access, and all sorts of ills that we can't even contemplate, because technology now makes anything possible. About 4 years ago, nobody was thinking about deepfakes, or some 5 years ago, nobody thought the time would come where technology will enable you to see videos that misrepresent people that never existed, so to speak, or speeches that were never made by someone, but were captured, like actually made by the person. So as technology continues to evolve, so also are the ills, so also are privacy violations. Of course, the importance of privacy or data protection cannot be overemphasized. Data protection, irrespective of whatever argument you want to make around it, either academic or theoretical argument, it protects privacy and privacy of humans. Yeah, but now it's been stretched to also provide corporate data, privacy of companies, but that's a stretchy argument. From the business perspective, yes, promotes trust between organizations. Before I came in, Mugambi was talking about two banks that wanted to review their contract around data sharing, around data storage, and then maybe for some issues, maybe trust related or not, one of the parties did not agree. Yeah, from a regulatory perspective, taking care of data protection makes you avoid some penalties from regulators or penalties from the courts or even criminal sanctions, because data breach is also a crime in most parts of the world. Now, the basic things that we would always talk about would be the terminologies around data. And the first thing we want to talk about is the personal data. And this is also very stretchy, also very elastic. You never can really conceive the elasticity of the term personal data. It could even be things that you would. It could even be something that relates to a third party. For example, the data of somebody's child could constitute the person's personal data. Yeah, if he identifies the person. So it is very elastic. So any information that identifies or relates, so these are the keywords: identifies or they relate to you. They have your personal data. And data processing also is any activity you perform on personal data. Anything at all, you record, you store, even if you don't use it, you store it somewhere. That's processing. You destroy, you misplace, anything, you alter. Then the data subject would be an individual. The laws are a bit confusing. I use the Nigerian provision, for example. Nigerian provision defines data subject as an individual. And we have been able to argue that an individual can technically mean a company. So does it mean the law protects companies too? These are arguments that can be made in court at a later date. I mean, if the issues arise. Then we have the data controller, who is that entity that determines the purpose or the means of processing personal data. There are arguments around whether churches would constitute data controller. And well, some of these things are issues that will be discussed when these disputes actually arise. And there is no limit to how these things can be stretched. Then the data processor are engaged controllers to process data for them. So people who use cloud storage, they are somewhat engaging data processors. So the principle, this is what I call the Trinity principle. And the good thing about data protection is it cuts across. Because we imported it from Europe, so most of us copy, almost all the principles, we can relate with them. Lawfulness, fairness, and transparency, this is what I call the Trinity principle that speaks to how lawful, whether your use of data is provided by law, whether you use it against the provision of the law, or you use it in such a way that it breaches the law, then it is unlawful. Or you use it to prejudice someone, it's unfair. For example, we've spoken about a situation where somebody working in a company's HR department, then you gain access to highly confidential, highly intimate data of employees, then you begin to use it against them. Or even the company, in the event of quarrel, company begins to divulge this kind of information. I mean, that's unfair. And transparency, this is where most businesses have problems. I used to say it, realistically, there's hardly any company in the world that can be 100% transparent. No. In fact, that's where we now begin to discuss transparency, the thin line between transparency and trade secrets for some transactions. So, I mean, you can't, especially where the GDPR requires controllers to disclose the third parties that they share data with. How many companies can disclose that realistically? And disclosure would mean identifying those companies, not just saying we share with our subsidiaries, but you actually identifying these subsidiaries, or identifying these your third parties, or identifying your vendors, or identifying your consultants. Not many companies can do that, but there's a lot of other things that I found almost impossible to comply with under these data protection laws. Purpose limitation, just strictly use data for the purpose of collection or for the purpose of the purpose disclosed. Data minimization, do not collect more than it is needed. And where you have data that is not needed, trash them or archive them safely. So that, because they say that big data promotes data breach. Accuracy. I have had some personal experience with accuracy, but I share it under rectification. I'm not sure I'm going to speak to rectification, but I'll speak to that. So accuracy, there's a way when you keep inaccurate records of people, you can prejudice them. You keep inaccurate record of someone. There's a case that I recorded in one of my books. I think Kelili and Switzerland. It's a decision of the European Court where a woman went to France or something, or a woman went to Switzerland, and okay, where a woman went to Switzerland. So I mean, I appreciate if you can help me so that I can monitor the time, because I know I have just let me know the number of minutes I have left so that I can rush some of these things. The woman went to Switzerland on vacation, but she was caught by the police because she was hanging somewhere on the road, and they checked her bag and they saw a note there that looked like she was a hooker. And they recorded, while they were profiling her, they recorded prostitutes as her occupation. She went back, or she fought it. She told them that's not her occupation. She's a businesswoman or something. And subsequently, she went back to Switzerland and she discovered that police still had that wrong information. She sued the police at the European court, and she sued the Switzerland, and she got damages. Now, there's so many ways where you keep inaccurate records, rights. That inaccurate data can prejudice. There's storage limitation. If you keep storage forever, you are setting yourself up. Because if you give me an impression that data will be kept forever, then people can keep coming back and exercising certain rights. For example, this organization hosting this event, I don't know. I've not read their privacy policy. I don't know if what it contains. I don't know what their storage policies are. I don't know what their storage schedules are. So I could come back in some 10 years and say, oh, you know what? Sometime January 23rd or 25th, I spoke at your event and I needed for a pitch. And because your storage, your policy does not state that you don't store it, and I know this is being recorded, so I can always ask for my recording, for my voice, for my face, for this session, just to show or to prove that I was actually here and I spoke. And trust me, if I can't get it, that's data breach. If for some reason you say you don't have it anymore, it is data breach, because part of data breach means non-availability of data. I could sue for it and I could get damages, possibly. I'm just looking at a scenario in the future where these things will play out, where people have given, so I had a personal experience. I opened an account with a Nigerian bank in 2003 or 2002. It's a corporate account. And subsequently, I misplaced the incorporation document, the certificate of incorporation. I remember I submitted it at the bank scanned it. So I wrote the bank to give me a copy of that incorporation document, because it's actually a business name and I'm the sole proprietor. So the bank wrote me, the customer care of the bank wrote me that they couldn't give it to me. I said, that's impossible. That's my data. I wrote them under the Nigerian Data Protection Regulation at that time. And I showed them that it was my right. And I showed them the damages they could suffer and the fact that I could approach the court. They saw all those things and they agreed with me. They gave it to me. It would have been bad, but it would have been worse if they did not have it. I could sue them and I get damages. Yeah. So that's about storage. Integrity, that is data security. Accountability, if you process data, you must be able to show that you comply with the relevant provisions. So I'm going to rush this. The frameworks, just the few frameworks. I don't know, but the organizers in their invitation, they particularly referenced GDPR. So I think they don't want us to look at Africa, even though this is supposed to be for Africans. So the GDPR is has been described as the global standard for data protection. Everybody copies the GDPR. The principles, we copy, the mechanisms, we copy, the rights, we copy. Like, this is a global standard, and that's why they introduced these adequacy requirements. Like Dr. Mugambi said, there should actually be many standards around adequacy requirements. There should be for each region. Because in one of the articles I wrote, academic articles, someone who was part of the process confessed that the excuse me, that the adequacy requirement is a tool to force other continents to also legislate data protection. So we have the California Consumer Privacy Act. USA does not practice the kind of data protection regulation they practice in the UK. In the UK, it is more standardized. In the US, it is fragmented. Then you have the Personal Data Protection Act, Singapore. I just used that. Then also the Privacy Act in Australia. I just also used that since we are speaking to international framework. But I honestly suggest this is the proper time for us to begin to dissect our own African laws. What I would have loved to do was to place side by side the Kenyan Act, the Nigerian Act, maybe the Cape Verdean Act, maybe the South African POPIA, and a few, and just do a little bit of crisscrossing around it to see the regular themes. But I had to follow what the organizers instructed. Now, we can be very theoretical about data protection, but it is more practical than we can ever imagine. For every organization, I think what starts first is creating a culture, a data protection culture, where even though you work in an office, but you don't touch their data, or you don't particularly, sorry, excuse me. I hope you can still see my screen. You paused for a while, sorry.
We just lost your screen, Doc, Olumide.
Yes, please, I'm coming back. Just, you can hear me, but I mean,
yes.
Just a second. I think my screen is off. Just a second. Yes. Okay, so I get it back now. Okay, so sorry about that. Yes. Okay, yeah. So
we can see
creating a culture around data protection. Yes, thank you. For either your company or organization, you should have some obligations. So we will always advise to have persons responsible for either data protection awareness or data protection implementations. What have you? Training, there should be regular training on awareness or something. I mean, almost every company who takes data protection seriously should celebrate the annual data protection day or the annual data privacy day, whatever you call it. That might just be an opportunity to further spread the gospel and let people know that there is such celebration. I keep looking at messages. Please just let me know how much time I have left. Then technologies that should be technologies that you should
have
use.
10 minutes.
And thank you. And everybody should get to use this. There should be some files that you don't necessarily paint their names out there. There could be codes identifying them, irrespective of the kind of businesses you do. Then data storage should try as much as possible to make sure it is secure. And then impact assessment should be something that should be periodically done, especially on new devices or new projects or new programs that will most likely impact data. Cross-border, these are the challenges in data protection compliance. Cross-border, nobody understands it yet. Nobody has been able to cage cross-border transfers. For example, we keep asking ourselves, what exactly is the meaning of cross-border transfer? Sometimes we call it cross-border flow. If we are able to define it, what are the examples? What are the practical examples of cross-border transfer. A company that buys tickets for its employees that travel abroad, is that cross-border? A company that has subsidiaries all over and they share emails regularly, is that cross-border? I mean, there should be clarity in the laws. Not many laws have such clarity, and that's why we keep seeing guidance notice. Some are specific, some are clear, some are not clear. The GDPR places restrictions on data transfer outside of the EU, but how practicable is this? I think they are only after the very big dogs that we know that they regularly transfer data, that they routinely transfer data. And so many countries have replicated this. I see it everywhere. And another thing about it, data cross-border transfer, everybody tries to be extraterritorial. The GDPR tries to be, but I am yet to see a GDPR being applied in Nigeria or in Europe, someone applying GDPR to companies in Nigeria, except, yes, like we have said, except such companies really target and they have huge presence in Europe, maybe. But the extraterritoriality, we are still trying to see how it will work out. I've not seen much of that. Maybe someone on the call has seen much, then we can discuss it. Then regulation, the EU and the US, they practice divergent data protection regulations or data protection approach. EU sees it as rights. America has commodified it. EU sees as a standardized regulation. America says it is market-driven and it is fragmented. There is privacy law in California, there is in, I think, Texas and some other states, but not more than 5 or 6 in America. So their approach is always different. Then America does not really have a dedicated regulator for data protection. Then balancing innovation, yes, tension. I started with this, that the innovation continues to swallow personal data, continues to swallow privacy. We filed a case against Truecaller in Nigeria that they use people's data without consent, without even any legal basis. They came to court and argued one funny argument, and the judge agreed with them. But we didn't appeal because we got to know about the judgment much later. But there's another case against Truecaller also. While Truecaller is innovative, because yes, it helps you to know who called you and who did not call you, or whether you want to speak to the person or not. But what about people's privacy? So what I do is, Truecaller cannot even tell you my identity, because I by myself, I put an identity there that doesn't. I pseudonymized my name, so I mean it won't tell you who I'm on the call. Yes. So then I think that's about my yes. So thank you very much. That's the end of my slides.
Thank you very much, Olumide. That was quite an informative one. I honestly wish we had more time. As you can see, it's become a bit dark in my area. We're experiencing a thunderstorm. Please just confirm that you can hear me clearly.
Yes, we can. I can.
Okay, fantastic. So thank you very much. I'm going to take some questions now. As mentioned earlier, there are so many screens here for me to go through. Please, can you indicate just by saying your name or I? You know, Olumide, you were talking about employee data privacy and some cases. Every time I go into this topic, because it's a sensitive one for me, I always refer to the H&M case from years ago in Germany, where they profiled employees by going to ask colleagues, friends, relatives about their sick leave, about other sensitive information, and obviously against the Data Protection Act in GDPR. And what I liked in the regulators' finding is that they were asked to pay even some of the employees and not just the regulator alone. So that was something quite new. But there's now quite a lot. Pardon?
I said that's quite impressive, yeah.
And one of our courts also fined against a data controller employer who used an employee's image for their advertising without their consent. So we're developing our own jurisprudence.
Yes, that one is routinely done by employers, just as you mean that all employees want to be part of that group picture. That's one. Then secondly, the use of the group picture. So websites, they put it there. Sometimes the employee has left. You still have the employee's picture on the website. You still have employee's picture on your branding and some other merchandise that you've done. I mean, this will continue to raise serious issues in the years to come, especially an employee that leaves disgruntled.
Yes. All knows about data privacy. Segura, you want to say something? No. Okay. Any other comments? Yes, Ayanda?
Advocate, thank you so much. I'm just coming in with a short question to find out if this is a series and if we can have the benefit of enjoying such content in future.
So Ayanda, thank you very much for the question. This is a masterclass and it is running from today being the first one. We have three sessions tomorrow as well as the 25th. It will not in this form happen again, but as we mentioned at the beginning, it has been recorded and will be available on the PHA YouTube channel. Thank you. Valerie?
Thank you, Mohale. Hello, everyone. My name is Valerie Waswa. I'm a certified DPO from Kenya and lawyer. So my question is with regards to the challenges around compliance, especially from a global perspective. And the question is that how do you get to balance sovereignty with, the free flow of data, especially with cross-border trade, commerce, and also with, the cross-border nature of the internet and technology. So at what point do you stop being Republican in your thinking and then think more towards, a globalization? And also what happens in instances where there are data sharing agreements, but certain countries do not comply with this agreement, and so it becomes a double standard. Thank you.
Thank you, Valerie. I think this was one of the issues we even discussed. Yes, please. I heard her very well. So, I mean, these are one of the issues that we discussed about properly understanding privacy and how to regulate it. Trust me, internationally, there are still many things. Oh, we talk about data localization, data sovereignty. These things are more theoretical than practical, especially from an African perspective. An African country that does not have infrastructure to store data on its soil. Then we're not speaking about localization. How do you even localize when the crowd storage systems that we use, they have their servers in Syria, they have their servers in Cyprus, they have their servers in Europe? How do you localize? So, I mean, and in terms of sovereignty or Republican, I think expedient what will judge or should be the determining factor. We don't have that infrastructure yet in Africa for us to be able to say we are going to be very we're going to be very strict around data sovereignty. I think it's a give and take situation. We have laws in Nigeria that speak to data localization. But the parliament that passed the law, the government, have they provided infrastructure to make that law really practicable? It's not possible. Nigerian banks still use foreign infrastructure for their storage, for their processing, for their softwares, a lot of bank softwares. I mean, when there was a cable, a submarine cable issue somewhere, I can't remember, maybe Middle East or something. Of course, it affected the whole of Nigerian banks. So what are we talking about? So, but again, the legislation could be there, the policies could be there, but I think expediency will always be the determining factor. Yeah. Thank you.
Thank you, Doc. Margaret Muse or Mose?
Yes. Good evening from Kenya. I'm Margaret. I'm a lawyer and I have interest in data privacy. I have a question. There was a case where parents came seeking legal advice. They were foreign donors who came and took pictures of their children, and they have published it in their website, and they are actually getting donations using those pictures. So in this instance, how will they be able to sue? Should they sue under the Kenyan law or in the given European country?
Thank you for that.
Okay, so they came to Kenya to collect their pictures, and if I got you well, then they put the pictures on the website. The money they were collecting, was it for the children or for somebody else? Was the money for them?
Yes, they're actually using the pictures to depict, because these children are from poor background. So they have published those photos in their website, and they're actually getting donations using those photos.
Donations for the children?
Yes, donations in quotes for the children, to help the children, but the parents are actually not getting the money.
Oh, but you may want to find out whether the parents signed any consent form or something. Getting money is another thing.
They didn't sign any
getting
consent.
money,
one person at a time, please.
Getting money is different. The privacy part is different. Yes, please. Yes, please.
May I
comment?
comment?
Just saying, Myra, can you please wait? Olamide is still dealing with Margaret's question. Once they are done, then you can add on to that if I do call out your name. Thank you. Margaret and Olamide,
yes.
are you done?
Yes, I'm saying they did not actually
so
sign.
I got that. Okay, if they didn't sign, of course, they can sue in Kenya. They are based in Kenya. They got the pictures from them in Kenya, and the website can be viewed in Kenya. Yes, they can sue in Kenya under your Data Protection Act, and it will fly. Yes.
Yes. So remember, most of the laws speak to processing in the jurisdiction. So these donors came into Kenya to process. And fortunately, with the Kenyan Data Protection Act, Dr. Mukambi, you can correct me, if you process Kenyans' information, you are subject to the Kenyan law, regardless of where you are
Wherever
based.
you are. Definitely. That's very key.
And you still have to disclose. Pardon? Go ahead.
Yeah, I said the Kenyan courts have jurisdiction. So the same way we sue all these multinational platforms. I mean, we have many cases against Google in Nigeria. We have many cases against Facebook. We have cases against Truecaller. They are not Twitter. They are not based in Nigeria. Because the data subject is in Nigeria and they process. So that's it. Yeah.
Dr. Mugambi, your contribution?
Yes, actually, Section 4 of the Kenyan Data Protection Act, just what Olumide said. So long as you're processing data for anyone who's resident in Kenya, you have to comply with the law. And then there are court cases against Meta, and the Court of Appeal in Kenya said anybody who's operating in Kenya, even without a physical office, you're subject to Kenyan law, including the Kenyan constitution. So those individuals ideally will be taken to task through the Kenyan legal system.
Thank you for that, Dr. Mugambi. Laura? Oh, sorry, Laura, can we give to Myra if you are adding to that question?
Hi.
Now you may speak, Myra.
Finally, oh my goodness. Anyway, I respect my seniors. They've really given us broad and wise advice, and which is true, because the lady who was asking about the data for the pictures for the child, when reporting, you report to the jurisdiction of the country. So if she's reporting in Kenya, the Kenyan legal frame applies. And that is technically also what my seniors will say. And if you are reporting in Nigeria, that is technically what my seniors from Nigeria will also say. So the court is bound by jurisdiction. And these are all lawyers, so they know. And the Data Protection Act, is very kind of limited. So when you're dealing with information, make sure that you are very keen on solving it bound by the country that you're in. If you have a client that is in the US, deal with the data laws that are in the US. If you are dealing with a client that is in Tanzania, deal with their laws for Tanzania. So
Thank you very much, Anna.
Yes, so
we've got a few hands up. If you can please sum it up.
So I'm going to sum it up in the same way that just use the Data Protection Act and the Constitution of Kenya and keep it in those lines.
Thank you very much. Laura?
Thank you. My question is basically around children's data privacy on the internet. Since the aftermath of the COVID-19 pandemic, we have had a lot of online presence by children because of, teaching and all of that. But the local and international laws have really not given protection for the children's data, because it seems like, okay, we have parental consent mechanism, but nobody's really checking because those mechanisms they're so weak and they can be easily bypassed. And now we have AI that is coming at such speed. I fear that, as time goes on, it will be so difficult for children to be online because they're so, they're naive and they're easily exploited. So at this point now, what are we doing or what can be done to prevent, the misuse or exploitation of children's data on the internet, especially by third parties, because we don't know how far this data travel. Is there any law or something that is being done? Because I've checked and I've not seen anything and it rings alarms in my head. So perhaps we have seniors here. Maybe there's something in the, in the oven that's going to help in that area.
Olomida?
Okay, so Nigeria has a Child Rights Act. Section 7 of the Child Rights Act protects children's privacy. Even the Nigerian Data Protection Act does not exclude children. So if it's just this, I think it's a straight rule. Any company, any entity misuses children's data without legal basis now. We've seen situations, that's the case we did in court, where they used some children's picture to advertise, and later we discovered that the parents were paid. So there would be a legal basis for that. But in the absence of legal basis, I think the available laws can take care. The only problem is regulation. That's where I see the problem. Because I know TikTok was banned in, was it US or in another country because of their child, because of their disposition to children's data and everything. So this thing, the laws are there as far as I'm concerned, but regulating or using these laws is another thing entirely. I think Dr. Mwaka wants to say something.
Olumide. Hi.
Dr.
Yes.
Dr. Kwanko?
Hi.
Yes.
Yes. If you could hear me, I wanted to react to the initial question about the child whose picture is used for adverts in Europe. For me, going to the courts is an option, but it is an expensive option, right? We could try. we could try the first approaches to see if the problem could be solved. I'm happy to draft a petition to the data control, the DPA of the member state where this NGO is located, and I'm sure they will react. I've had personal experience with this Nigerian law and a data controller or processor that is outside Nigeria. Sometimes it doesn't work when you, or any other African country. You may sue them and they don't appear in court, right? However, we could approach this way. Let me know if you want, I could help. We draft a petition to the authority involved, and that would even serve as a good evidence when you are approaching your local court. I think that could solve that. In some cases, they will stop at the first letter, honestly, because they know the hefty fine that is facing them if they are found guilty.
Thank you for that, Dr. Nkwanku. Just to add on to that, any person, there's no law that I've come across where it restricts the people that can actually complain against the data controls violation of the Data Protection Act. So any person anywhere can lodge a complaint. And, you know, when we talk about laws and regulators protecting children, I think the first step is as parents, I'm a parent to a 14-year-old boy. And the first step is in me protecting him and not just going into Facebook. Facebook allows us, how old are you? And if you are underage, then it says, do you have parental consent? But what do the children do? They say they are over 18. And even as parents, we say, no, we are over 18. So it starts with us as parents, it starts with us as communities to teach children how to protect themselves, and we protect them on the internet as well. Laura, you've got your hand up. I'm about to wrap up the session.
Yes, I'm sorry, just to double back on what I said. So, you know, we've talked about using children for adverts. I feel like if that was all that was being done, it's safe compared to, you know, the true realities of what we have online. Because now for the internet space, like the dark web, there's completely no regulation for the dark web. And that's where all the most atrocities go on. If it was just adverts, at least we can see that. But in the dark web, we cannot see anything. There's no information. So the law does not, who will the law apply to? Where does it go to? So it's like, there's no regulation on the dark web. So are we going to pretend like it doesn't exist?
So Laura, just to close off on this, the law applies to everyone. It's just that there are some players out there that disregard the law, and then the problem becomes enforcement when you don't know who exactly is breaching the law. So I hear you. I'm not disregarding anything, and I think we are all aware that children's rights and just vulnerable people's rights and protection needs to be enhanced, and somewhere, somehow, something should be done by the powers that be. And
I also say,
Dr. Olamide, I was just about to close the session, so please have the floor.
Yes, I also said this also. So I mean, I try to flip it, especially for the parents, here. Can we also be very mindful of creating unavoidable or unintended digital footprint for our children? I know a lot of parents who anything, you see their phones, you see their social media, you see the children's faces, you see the children's videos. So from what I understand, when you put these things there, you are feeding these dark web, like you call it. You are feeding organizations or entities who want to manipulate or exploit this data. So for as much as we can, our children's videos, pictures, yes, we know we want to show the world we have children, but perhaps some are not even done by parents. Some are done by older siblings or uncles or aunties. I think we can do better than just giving these children unnecessary digital footprints. Thank you
very much, Olamide. As mentioned earlier, it was a very informative and it was an engaging session, and I believe we could go on and on and on again. Unfortunately, Rachel and Chwala, we've closed off on this session. we're going to move to the next section so that we stick to our promise to inform you on a lot of stuff. So now we're going to talk about cross-border transfers. And this has been brought up in the last two presentations, and questions have come around this as well. But here we are specifically speaking on best practices for handling cross-border data flows, particularly in context involving multinational organizations. So there was a question there that will now be answered by Benga Odubemi, who is an accomplished privacy attorney with extensive experience in both in-house roles and consulting at leading global firms, such as PricewaterhouseCoopers, PwC, EY, and over the years, he has built a reputation for helping organizations across various industries navigate complex privacy regulations while aligning compliance with business objectives. To simplify access to privacy legislation, Benga developed a pre-plug, based on Privacy Plug, a mobile app designed to help privacy professionals quickly reference and navigate privacy laws. The app is available for download on major app stores and serves as a valuable tool for industry practitioners. I am downloading just now. He also specializes in assessing organizations' privacy maturity levels, identifying gaps, and providing senior management with detailed reports and remediation plans to address compliance challenges. His expertise extends to working with internationally active organizations, giving him deep exposure to privacy laws across multiple jurisdictions. A seasoned professional, Benga has helped global organizations establish robust privacy programs and strategies that ensure compliance with diverse privacy laws. His practical and strategic approach makes him a trusted advisor to organizations striving to enhance their data protection capabilities. Benga, may I please hand over to you for the next 30 minutes. Benga? Am I saying your name wrong and you don't recognize it? Can anyone hear me?
I can hear you.
Yes. Loud and
Yes,
clear.
I can.
Okay, so it's not me, just hold on.
Can hear you
Like
loud and clear.
SAA in the former days, we are having technical issues. Please hold on before we take off. Okay, while we resolve that issue, can we take any comments on how you're finding the course so far? Do you have a burning question that you would like to ask? Rachel, your hand is up. Is that intentional or?
Hi. Good
Go for
evening,
it.
good morning, good afternoon, depending from where you are joining the call. So I wanted to make an observation concerning the issue asked by Laura Ude, I think, Laura Ude. Sorry if I'm not pronouncing the name correctly. So it's about, we know that generally the internet has been a hard bone to chew for decades, right? However, with the development of international law, issues like fostering cooperation and understanding among nations have ensured that to a large extent, some of these problems that we face on the internet, like child pornography or even the indiscriminate or harmful sharing of children's pictures, are being dealt with. So because the dark web it is quite challenging to regulate that, maybe nationally, it's possible with this, with the fostering of this international cooperation, issues like this may be dealt with, but it actually depends on how, to what extent is the sharing harmful, right? Is it very harmful? Is it done in a way that harm the children? And on the issue of legal basis, like a parent consenting or even sharenting, sometimes the consent being the legal basis cannot inherently cure the problem that we have concerning balancing the interest of the child and that of the parent or the organization that is posting it, right? So it should be determined based on a case-to-case basis. Is the child's interest greatly affected if these pictures are left? I think that should be the duty of the court to determine that, not that because consent is there as a legal basis, then henceforth, because even legal basis, implementing legal basis does not mean that, processing data based on those legal bases, it doesn't necessarily mean that controllers or processors cannot be held liable to their processing activities. That's what I wanted to add.
Thank you for that, Rachel. You speak into the ethical processing of personal data, and it is something that we hardly ever look at. But as data privacy professionals, it's our responsibility to bring those into the discussion. I don't think any regulator or any court is going to say to a data controller that's flouting legislation that, yes, you complied with the letter of the law, but did you comply with the spirit of the law? And just ignore that requirement. In compliance, we do say you don't only comply with the letter, but also with the spirit, and looking at ethical things. Privacy is not a program or a concept that you can implement in isolation. You have to look at all the other laws. And in our space, South Africa and the UK, we have treating customers fairly. Customers are data subjects. So, and it speaks to more than just the letter of the law. Can I just check if Benga's on the line and ready to go, or if we can take another comment on that topic?
No, I'm actually here. I mean, I can go ahead. Presenting this is amazing so far.
Okay, thank you. The floor is yours. You may share your presentation. Welcome.
Awesome. No, thanks a lot. Let me know if you can see my screen.
We can see it.
Amazing. Hi everyone. I don't know, should I turn on my video as well? Can you see my video?
Yes, we can see it.
Interesting. So the topic I'm speaking about, of course, I think everybody already knows. Cross-border data transfers, best practices for handling cross-border data flows, particularly in context, involving multinational organizations. So to start with, right, if you don't pick anything from this presentation, I want you to pick up this last quote, that I put right here, that in every cross-border international transfer of data, in practice, because I like to talk about privacy in practical sense, versus theoretical sense. So in practical sense, where the personal data is coming from is actually much more important than where it is going, right? The laws, of where the data is coming from is actually the determinant of everything. So always have that at the back of your mind when you deal with cross-border data transfer, that the laws, that regulates personal data, where it is coming from, is much more important than where the data is going. So with that said, let's go. Let's see the content. I have, let me see, 1, 2, 3, 4 headings. Introduction, the requirements for cross-border transfer in some jurisdictions, which I think we should probably skip, but we can go through it. Then we go to the meat of the presentation, right, which is the best practices, and then some considerations you should have in mind as you think about this whole thing. So introduction, these 4 things are things that I think creates like a basic I would say foundation to like understand what we're trying to discuss. Many thanks to my to Mr. Olumide, for that presentation. I think it creates like improve the knowledge on what we're about to discuss as well, right? Let's go into it real quick. So what's cross-border data transfer, right? In privacy discourse and practice, when is it set to have occurred? And don't worry, I think I can share this PDF file with you guys so you can have it. Now, a cross-border data transfer refers to the processing of personal data across national borders, right? For most people, when they hear cross-border data transfer, they think of data is actually being transferred from one country to another country. But in privacy discourse, privacy parlance, you don't actually have to make that transfer, right? It could be that you're just disclosing it or you're just showing someone. So you don't actually have to transfer. So if I'm in, let's say country A and country B, right? If I'm in country B, if I'm able to access data in country A, right? Country A is making the data available to me from country B. Like I can go online on their website or through a link, whatever, and I can see the data. It transfers happen, right? So the people who drafted the privacy laws are very, very, smart. If you look at Section 2 of Kenya, DPA, and even Section 1 of POPIA, where processing is defined, you see that it goes beyond transfer, right? It entails retrieval as well, disclosure by transmission. So the whole essence of this definition is so that you know that in your organization, a cross-border transfer might be happening and you might not even know, right? I know you guys might have questions, but let's keep going. I'll take questions later on. So why transfer personal data internationally, right? The most common reason why companies transfer data internationally is business operations, right? I'm a company in South Africa, but look, I'm trying to expand to South Africa, to Nigeria, to Kenya, to Zimbabwe, to Europe. So as a company, as a government rather, you should enable companies locally in your country to be able to do business internationally, right? So the main reason why companies transfer data internationally is because they want to expand, they want to get big, right? They want to have operations and serve customers in other places, and that's why they transfer data internationally, right? The second reason, of course, or point is that countries want to maintain some control over how their citizen data is handled, even when processed elsewhere. So most countries, like the EU, for example, or even any country for that matter, right? If you collect data about their person, about citizens in their country, they want to maintain some control, right? And that's why you have laws surrounding cross-border data transfer. Also, different countries have different levels of data protection and privacy laws, and transferring data to a country with weaker protection could expose individuals to risk. So a company might think like, look, a country, right, let's say the EU, for example, might feel like, don't transfer my data to South Africa, over our citizens in South Africa, because they don't have good, data privacy protection measures in place, right? If you want to do it, these are the things you must do, though. I'm not saying you can just go ahead and do it. You can't just go ahead and do it. But if you have to do it, these are the things that you must do. But what really informed that is because Europe thinks or believes that South Africa and every third country, have weaker data privacy protections. The last one I have this: cross-border data flows have economic and security implications, and regulations can be used to manage this concern. So classic case, the TikTok situation between the US and China, you know, it's all economic and security implications. You know, the US government occupying a space of parents patria in law, they are trying to take the space, you know, as a parent for US citizens, because they believe that TikTok is taking Americans' data to China. And that has security implications, because China, if you look at their law, they can actually ask the parent company of TikTok, which is ByteDance, to provide access to the data of Americans that are collected by TikTok and transferred to ByteDance in China. So that's why you have cross-border data flow, you know, laws. And to be candid, it's fair game, you know, what US is doing, because if we look at Europe, Europe has a version of law, the privacy, the GDPR, right, that stipulates what happens when European data is being sent to China. You know, there are certain things you have to do, right? You even have to do a transfer impact assessment. America doesn't have such version of law. So you're taking the route of don't even transfer our data to that place, right? You're collecting so much data, keep it in the US. But that's politics. I don't want to talk more about that. Just, you know, something to give you an insight. Now, the third thing I want you to understand about this introduction, or under this introduction, is that there are two likely scenarios that cross-border transfer might happen. It's either intra or inter, right? Intra-company transfer, as you guys probably know, is where you have like 5 or 10 companies, like the way you have ByteDance in China, and you have TikTok incorporated in the US, and you have TikTok UK, TikTok Ireland. These are the same company, right? The same company, but in different jurisdictions. So when they transfer data between themselves, that's intra-company data transfer. Now, when a company transfers data to another entity outside its group of companies, that's inter-company transfer. You must understand that these are the two forms of cross-border transfer, because the requirements in law or things that you must do, or the best practices for both of them, right? Are we transferring data internally or externally, right? I'm trying to look at my time so I don't spend too much time on the relevant stuff. But this topic, if you look at the title of it, like it says involving multinational organizations. So what that ordinarily suggests, this discussion is going to focus more on intra-company transfers of data, not inter, because it's a multinational. If it's a multinational, you know, what we are saying is that we are staying, you know, within the same group of companies. It's multinational, right? But I didn't restrict this discussion to that. It was largely more of intra-company transfer, but I also provide insight on intercompany transfer, as we shall see. The last thing I believe that I want you to know, you know, as we discuss this topic, is the difference between data localization and data sovereignty. I know this issue has been mentioned earlier, and we've spoken about it, but localization is just saying, like, look, keep the data within this jurisdiction, right? Within this place, within this country. Keep data over here. Sovereignty is just more of like the government of where data is collected or stored, saying that I have the ultimate or sole control on this. The government is saying it, right? I have sovereignty on this data, so I can tell you what's going to happen. For example, because I have sovereignty on this data in Europe, right? The European Commission is saying that because I have data sovereignty on Europeans' data that are processed or collected in Europe, if you're going to transfer that data to any country, these are the rules. That's data sovereignty. The government of where data is collected or processed has some sovereignty on the data that's collected by a company. So data localization is actually a function of data sovereignty, because the government that has data sovereignty can say that keep data locally, right? I would pause there to see if is there any questions so far? that I can take real quick before I go to the next stuff? I want this to be interactive, right? I don't want it to be that I'm just talking. No question? Okay. Seems to have been doing a good job.
Question from Dr. Nwanku.
Hi, Wenga. In the EU, the Court of Justice has ruled that the mere fact that somebody views an internet page from another jurisdiction does not constitute data transfer. Linguist case, I think I don't know I know the citation. I could also supply that. Is that different from what you have observed from the definitions of processing? I know you mentioned, I think, Kenya.
Yeah.
So did you try to compare this with what is in the GDPR and whether the courts in Africa would follow this EU principle or this EU opinion based on these definitions you mentioned?
Yeah, very good question. And I actually emphasized that question. I was actually going to touch on it, and I was hoping someone asked that question. Very, very brilliant question. So in privacy, context really matters, right? So the fact that I'm accessing a website, like let's say the BBC website, right, which is obviously hosted in the UK. I'm in the US, I'm accessing that website. There's no international transfer. Context of the situation is what really, really matters, right? So if users are just accessing your website of a company in another country, that's not international transfer or cross-border transfer. They're just looking at website, right? A cross-border transfer happens where a company and another company, right? It's always two entities, right? They're actually in business or doing something that mandates or necessitates the transfer of data. So to answer your question, it's a function of context, right? Like what's actually happening. If an individual or users are just like browsing your website and your website is in South Africa and they are in Nigeria, I'm browsing the website in South Africa, that's not cross-border transfer. But when the company in South Africa is transferring data to another company in Nigeria, now we have some, I had Mr. Olim really talking about the setbacks in data localization, in the sense that most servers for cloud service provider is not even in Nigeria, in Africa. In Nigeria, we have some cloud service providers, right? So let's say a company in South Africa is transferring data to or hosting their data with a cloud service provider in Nigeria. Now that's cross-border transfer, right? It's different from people just accessing a website. So context, very, very important when you think of cross-border transfer. I hope that answers the question, but let's rush into the requirements for cross-border transfer in some jurisdictions, right? In Europe, and this is just a function of law, right? If you look at several, so I don't want to make this a EU thing. You know, we are largely Africans. I'm a Pan-Africanist, right? So I'm much more interested in talking about African stuff versus EU. But look, to understand most of the African stuff, you might need to understand the EU stuff. But I can tell you that I actually have stuff in Nigeria or South Africa and Kenya, right? So, but let's look at it. What does the EU say when you want to transfer data? The EU is saying that, you know, we've whitelisted some countries that you can transfer data to without doing anything, no sophistication, just transfer to them. That's the adequacy decision. Then you have the appropriate safeguards, you know, the SCCs, the BCRs, approved certification mechanism like the EU-US DPF, specific derogations as well. You know, I'm brushing through this very quickly because this is not really the core of our presentation, right? This is just like what the laws have said, right, on how you can transfer data, right? The things you must put in place if you must transfer data. In Nigeria, we have something similar to what, you know, operates in the EU as well. We have adequacy decision, you know, where you can transfer data to without necessarily doing anything, you know, so no sophistication, right? You can just transfer to those places, which personally, I actually it doesn't sit well with me because Nigeria has this list of countries where you can transfer data to, and most of them is all EU countries, you know, and all these America, Switzerland, and France, and all of them. So you give adequacy to these countries, but these countries don't give adequacy to you. EU sees Nigeria and Africa, in fact, all 54 African countries are seen as third-party countries. Nigeria, the biggest African country, you give EU an adequacy decision. That's a travesty, right? It shouldn't be so, right? It should be something like a reciprocate. If you want to make EU an adequate jurisdiction, EU has to make Nigeria an adequate jurisdiction. But that's politics. I don't want to talk about politics, but I want to talk about what actually obtains, you know, in the law. Don't forget the quote at the very beginning of this stuff. I told you, said the laws of where the data is coming from is much more important. So as you navigate international transfer of data, you look at the laws of where the data is coming from. So in EU, you look at the laws of EU. If you're transferring from EU, you don't look at where the data is going. No, you look at where it is coming from. If you're a Nigerian company, you look at the laws. What does the NDPA, the Extant Privacy Law in Nigeria, what does it say about transferring data out of Nigeria, right? You don't look at where am I transferring this data to? Yeah, that's important as well. You know, for example, to determine if, you know, it's adequate, if you can transfer data to that place. But the Nigerian law sets the primary tone and says, this is what you can do. This is what you must put in place. Okay, in South Africa, kind of similar as well, right? They have binding corporate rules. This is subject consent. You know, the transfer is related to performance of contract, and the transfer is for the benefit of the data subject, all of that stuff, right? Like I said, this is something you must do. You must look at what does the law says about the country where you're transferring data from, so that you can know what mechanisms. This is very, very important. You can do it personally, you know, if you're a privacy person, you know, professional in your company, or you can do it with the privacy lawyer in your company as well. But for every country, you must understand what are the mechanisms for international transfer of data. Kenya, I love Kenya so much because I like some of the things I'll be talking about. In Kenya, you can see that the cabinet secretary may impose data localization, right? So they actually have a cabinet secretary that can say, this type of data cannot leave Kenya, right? Much more importantly, in Kenya, sensitive data can only be transferred only based on the data subject's consent and obtaining confirmation of proposed appropriate safeguard by the data exporter. So what that basically means is that in Kenya, they took the whole exercise, a little bit forward. That look, sensitive data, of course, as defined under the Kenya Data Protection Act, you can't just transfer it out of Kenya. You must obtain the consent of data subject and also meet, with the cabinet secretary to obtain confirmation before you can transfer. What that tells you goes back to what I mentioned earlier about data localization and data sovereignty, right? Now, the most important thing you should take away from requirements for cross-border transfer in some jurisdiction in the context of this discussion is that you must be able to determine what mechanisms are in place or can be leveraged when you're transferring data out of certain countries, right? You must be able to do that. And it's a function of law, right? You have to go look at the relevant laws, look at the section on cross-border data transfer, and look at the allowable mechanisms you can use. Is it consent? Can you transfer if it's for contract performance? Are certain countries whitelisted as you have in Nigeria? And even though I don't agree with the list, but look, that's the law. You must be able to do that. That's the most important thing you must take out from this stuff. So let's keep going to the best practices. Now, actually, before we go to the best practice, do you have any question on the requirements on this part? Do you have anything, any question? Any question? Okay.
No, you're doing a good job.
I'm doing a good job. Okay. It seems like it. Thanks a lot, guys.
While
So
you're taking a breather, Benga, you have until 25. So it's 16 now, 25. So it's 9 minutes left. Thanks.
You said what? I didn't get
You
that.
have 9 minutes.
I have 9 minutes left?
Yeah.
Oh, I thought this for 1 hour.
30 minutes and then 15 minutes questions.
Oh, okay. Okay, cool. Let me rush through it then. So let's go to the best practices. So for so don't forget, earlier I mentioned intra-company transfer and intercompany transfer. Those are the two ways you can transfer data, right? Those are the two scenarios it can happen. So for intra-company transfer, the first thing you want to do a mapping, right, of applicable jurisdictions where your entity exists. So don't forget, talking about a multinational, right? So the first thing you want to do is like, where are we even located? Are we located in Nigeria, South Africa, Kenya, right? These are the places we are operating, right? What personal data are we transferring? You know, where is it coming from? Where is it going? The note over here is just saying that you might want to also delineate, are you transferring normal personal data or sensitive personal data? Because there are certain laws, you know, that might affect what you can do with sensitive personal data. We saw that in Kenya just now. In the UAE, for example, PHI cannot be transferred out, right? So you might want to, like, as you map, also say, this is personal data, this is sensitive as well. The second thing you want to do is examine the applicable privacy laws in the relevant jurisdictions, right? To understand, and which is what I discussed earlier, right? To understand their requirement, right? Out of the jurisdiction, you know, some stipulate data localization, but the most liberal ones actually state mechanisms that you can adopt, right? Don't forget, of course, if any of those laws says data must be localized, for example, in Russia, all data must stay in Russia. What you have to do is talk to, you know, create mechanisms, you know, speak to service providers in that jurisdiction to keep data localized in that jurisdiction. You might also have to like monitor them so they don't themselves transfer data outside, you know, the relevant jurisdiction. The third thing, you know, is you want to consolidate, right? BCR perhaps, or standard contract, is the best form of intra-company transfer for multinational companies, right? What you want to do is consolidate. By consolidate, I mean like after you've mapped all this country out. So let's say Nigeria, South Africa, Kenya allows for you to use BCRs, which is like just rules or standard contract. That means, okay, let's say we have branches in South Africa, Kenya, Nigeria, Zimbabwe, and EU countries. If 3 of those countries allows BCR or standard contract, that means you can create, you know, a document, a huge document that has the proposed standard contract for the transfer of data for, let's say, for Nigeria, South Africa, and Kenya, for 3 of them. Now, you haven't talked about Zimbabwe and the EU because they don't have that. I'm just using that as an example, right? These 3 have it. So let's consolidate this one. Let's have a BCR for that, right? Now, for multinationals, it could happen in 2 ways. It could be that transfer happens frequently. If it happens frequently, then that means all the entities, data importer and exporter within the multinational, all entities in the multinational will just sign the document so that transfer can just keep going, you know, frequently, right? In such situation, that's the best actually, because it's one-time signing and that's it. The only thing that would change the contract or the BCR is, let's say maybe the supervisory authority make new rules on BCR or the law changes on the terms of the standard contract itself. Maybe a new one is proposed as they do in the EU. Now, if it's not so frequent that you send personal data cross-border in a cross-border manner or internationally, what you do in such instances that big document, you don't sign it once with everybody. You sign it just based on situation, right? You can sign it for each transfer. So let's say we are transferring we have branches in those 5 countries I mentioned, right? Nigeria, Zimbabwe, Kenya, South Africa, and the EU, right? And the transfer between these 5 entities is not so frequent. So that means anytime we want to transfer, let's say between Nigeria and South Africa, we use that large document, but we delete the other part. We delete, so it's between Nigeria and South Africa, right? We delete Kenya, we delete Zimbabwe, we delete EU because it's just between the 2 of us. So you have to understand that there's no point using the large document that contains this standard contract from all the 5 countries if it's just between 2 countries, right? If it's between 2 countries, you have to delete the other ones and but that's for infrequent transfer. I'm sure you guys get the gist. The 4th thing is consolidate further. So let's say between the 5 countries, 3 of them allows for standard contract or BCR, and you've already done that, right? You've created a document, a large document for that. Look at your other jurisdictions as well. Look at what is common for them as well. So consolidate further. So maybe for the other 2 or 3 of them, maybe 2 allows for consent. Then leverage consent for those 2, right? Keep consolidating like that. Look at the requirement for each country and consolidate as much as possible, right? Quickly, for intercompany transfer, the best approach is a subjective one, right? Intercompany transfer suggests that you are transferring, this is not between you guys again, this is between a company and an external company. So that means you have to take a one-by-one approach, it's subjective. So what you do is that you establish a basis for the transfer. Like I said at the beginning of this presentation, the law of the data exporter is much more important than the importer's law, right? So you look at the exporter law and say, what does it say? How can we transfer data out of this place, right? You establish that basis and you collaborate. And, a typical example of international transfer is where you use a service provider, like the Nigerian South African company using a cloud service provider in Nigeria, right? You look at the law in South Africa, what can you do to transfer South African data to Nigeria, to a company in Nigeria? You establish the basis in the South African law. It could be contract, right? It could be an standard contract. Then you tell the Nigerian company, you collaborate with them and say, look, our law says you can only do this, we can only do this by contract. And then you collaborate with them and you agree on signing a standard contract for that. That's it. International intercompany transfer is quite straightforward. But overall, as you do all of these things, and this is the last section, right? 7 things you should look out for that you should, as you do all of these things I've mentioned. Prioritize transfers for countries deemed adequate. It's easy, right? When you do your mapping, countries where you don't have to do anything, where they have been, transfers to countries where they've been whitelisted, those are the ones you want to prioritize because it's easy. You don't have to do anything, right? So have that in mind. Your privacy notice, Mr. Olumide was talking about transparency the other time. Some privacy laws actually impose that requirement where you must state your cross-border transfers. Where are you transferring to? What's the purpose of it? Who are the recipient countries, right? So think about that as you do all of those things I mentioned. Also, you want to monitor. So laws and regulations, in the exporter country changes often globally. So you need to establish a system to monitor changes in international data protection laws on cross-border transfer because it changes. Most of you know we have the safe harbor for EU and US transfer, but it was invalidated in, I think, October 2015. Then we have the Privacy Shield, invalidated in, I think, in July 2020 or so. And then we have the DPF now, that's active right now. So you have to keep up with what's going on in the world. This is the only way. And of course, number 4, you have to conduct regular audit of these transfer practices, to ensure that you are complying, continuously. So you already have your system in place based on the law. 3 months later, go back to how you're transferring data and just like audit it. Like, are we still good, or we're not good again, right? If you're not good, then you have to make update. The last 3 points. So number 5, where transfers from the EU. This is very narrow to EU, right? Transfer impact assessment, we all know what that means. It basically means when you use SCC, standard contract, as a mechanism for transfer from Europe to third countries, the European Commission has also said they should do a TIA, transfer impact assessment, which is an assessment of the law of the recipient country. Now, it might be so quick. Your transfer impact assessment might be so quick. Maybe the country has a version of privacy law as well. They're really good. They respect human rights, everything. Everything is good. But maybe that country has changed. Maybe they've now become like a China or a North Korea, right? So you have to keep looking at as law changed in the recipient country, but that's specific to EU, right? As I mentioned in number 5. Number 6, you must develop and enforce a standard operating procedure or policies for data transfer, ensuring all employees understand. Your employees are like the backbone of this. They're the ones doing this international transfer. You might not even be part of it as a privacy person in your company. You must create, so most of you guys who are in cybersecurity know the difference between SOPs and policies. Policy states why. Why are we doing this? The SOP states how, right? So you must create your policies which state why and how, so that your employees know that if they have to transfer personal data internationally, these are the steps they have to follow, right? Number 7, which is kind of similar to number 6, is you have to train your staff about data protection obligations, best practices surrounding international transfer of data, right? These are my 7 considerations with the best practices that you should actually, take into consideration as you do intra-company transfer and inter-company transfer as well. My app, Preplug, the best app, it's the only app in the world actually that combines selected privacy laws in different jurisdictions. You can just access it, go to the relevant jurisdiction, look at the country, and then go to the section on cross-border transfer and learn what are the mechanisms for international transfer, right? You don't need to go online and start Googling what laws are applicable in the UAE, Nigeria, and South Africa. No, Preplug already did that for you. You just need to go there and highlight the relevant section of the law. That's where the actual work actually starts, understanding the mechanisms. And as you understand the mechanisms, you consolidate, right? If you are in like 10 countries, if 5 of the countries allow standard contract, then you're good. Create a large document that creates a standard contract for those 5 countries. If you have 5 more, let's say 3 of them allows for consent. As you review the law, then make those 3, we're going to use consent for this. The other 2, maybe they don't even allow international transfer. They require data localization. Then work with local providers to ensure data is actually localized. That's my presentation to you guys. I think I stopped at 11:30 in the dot. So, any questions?
Thank you very much, Benga. Yes, we will download the Preplug. It will be a very helpful tool. I am looking at the screen for questions.
There's no question. Must have done a very good job.
Victor,
breaking things down.
Hi, Benga. Great presentation. Sorry, it's not really a question. I'd like to ask, can we have the presentation slides, please?
Oh yeah, I said that. Yeah. I said at the beginning. I said I'll share it. Yeah, I know it's important that people are able to review the information again. So yeah, I'll share it. Privacy Hub has it. I mean, they can share with you guys, but yeah.
Samuel, iPhone.
Okay, thank you so much. Thank you, Mr. Benga, for this wonderful presentation. I just want to seize this opportunity to say that Benga is one of those that brought me into privacy space, and he greatly assisted me when I was coming into the space. So my question centers on the question Prof had asked. That's Dr. Nwankwo, saying that there was a case that by the Court of Justice of the European Union that it may not constitute international or cross-border flow of data where an individual accesses a website or something like that. So my question, or a follow-up question to that decision, is what happens where that website has a cookie, maybe an analytical cookie, right? That's probably that is situated in another company, in another country. So would that still not constitute, following this decision, will it be right to say that that will not constitute cross-border flow? Because I think I've heard either a decision by the Court of Justice of the European Union or maybe one of the regulatory authorities saying that Google Analytics or the likes, may probably constitute a cross-border flow of data. So I don't know if one is clear.
Yeah, no, it's clear. I mean, I try to understand it. I mean, I can repeat what you said just so that you understand. I understand your question. So you're saying that placing cookies on a website, right? And if the data is even going to, if the cookies is owned by a third party company in another country entirely.
Let's say Google Analytics, yeah.
Right, in the US, right?
Yeah.
Being placed on a website, let's say the website is in Europe, right?
Yeah, yes.
Yeah, so you're asking, is there a data transfer?
Yes.
Right, so for cookies, so like I said earlier, you have the context is what really matters, right? So when a company engages Google, right, to do the analytics, right, there's actually a contract between the company and Google. Do you understand? So that's cross-border transfer. Two companies sit down and do an inter-country relationship and say, Google, do this for us, right? Company A actually in Europe actually has a contract with Google to use Google Analytics. So it makes sense for them to also agree on a cross-border transfer mechanism. Do you understand? This is totally different from where I'm just sitting in America and I'm Googling a website in South Africa. That's not, South African companies are transferring data to me. You understand? So it's totally two different situations. I don't want us to mix it up. For a cross-border data transfer to happen, you must look at the context of how it's happening. Company A and Google Analytics actually have a contract, an MSA, Master Service Agreement. And like I said, in my discussion, you collaborate, establish the business with Google Analytics, Company A and Google. The tool being used to Google Analytics, right, provided by Google. But Company A and Google must collaborate and highlight what's the best basis for this international transfer that is happening, because it's happening. Google Analytics is actually doing that. So you agree on the basis. So again, it's a function of context and understanding the relationship, what's going on. Do you understand? For every cross-border transfer to happen, there must be two entities. One must be a data importer and one must be a data exporter. If you don't see these basic requirements in what is being described to you in your company, then there's no cross-border transfer. Don't forget, cross-border transfer is an add-on to an actual contract, to an actual relationship between two entities. And an SEC cannot exist on its own. An SEC, in fact, an SEC is actually a third mechanism. The first one is a contract between the two companies. And the second level is a DPA, a privacy agreement. Then the privacy agreement will now inform whether there is an international transfer, which will now lead to the third thing, which is, okay, should we use an SEC? Are we whitelisted? Do you understand? The first place to start is there a contract? Is there a relationship between the two entities? And then the DPA comes in, then the SEC comes in, or whatever basis you guys have collaborated and agreed on, right? So
that's absolutely right, Benga. You need to look at the parties and also look at the definition of processing and personal data. So cookies, IP address, etc., that's all personal data. Collecting it is processing, and where it lands at would then determine the transfer being cross-border or otherwise. We're running out of time. I'm going to take one question from Oludare and then go to Benga to close up.
Maybe to Benga from me. One for me.
Just hold on, guys. Hold on. Please allow me to facilitate. Everybody's Rachel, can you switch off your thing? Please, Oludare first, and then Eric, you've had your hand up so many times and I've closed on you. So I will allow you to ask your question or make a comment, and that's it. Oludare, please make it brief.
Thank you very much. I want to say a big thank you to Benga and all the other speakers, Dr. Mugambi and Olumide, for the brilliant insights, for the great presentations you guys are giving us tonight. It's really awesome. Just one comment on one of the things you started with regarding why adequacy was not considered for maybe some countries. I just wanted to say that, well, I don't really think it has much to do with politics as well, but issue of adequacies and the rule of law. We all know that this is the bane of African countries, and because this is African privacy we're talking about,
right?
And it's good for us if we look at, could we do something better? Could our leaders do something better whereby we respect the law? You know, it's usually in Africa that someone could say, don't you know who I am? But we know in the Western world, nobody is anybody. If you fall foul of the law deals with you. And that is where the issue of adequacy comes in. When we're talking about data protection in Africa, while they can say, don't send my data to so-so place in Africa or wherever, it's not much because it's an African country, but because of the issue of adequacy. So the moment we start respecting the rule of law and we put the adequate controls and mechanism in place, then we too can be listed as part of the countries that have adequacy decision ruling. So that's just the thing I want to say. Overall, I say thank you so much for the best practices. Thank you.
Thank you so much, Oludare.
If I can quickly respond to that, Mr. Oludare.
Very quickly, Benga.
Yeah, very quickly. Yeah, less than 10 seconds. I think you've made a very important point. My submission is a function of a proper understanding of international law. Most of international law principles are based on reciprocity. So if I'm saying that people can transfer, Nigeria, for example, I'm saying people can transfer data to your country and companies don't have to do anything. The least that you can do is tell your companies in your country that they can do business with my country people as well without any sophistication. So that's what I'm saying. Nigeria has no business giving Israel and all these, hundreds of countries adequacy decision, right? When they don't even see us that way. I think we have a chance here to take a lead and say, no, this is how it's going to be. You reciprocate or it doesn't happen at all. They want to do business with Africa. Africa doesn't need these countries. They need us.
Benga.
So that's my position.
Eric, can I please give you an opportunity to speak before we are cancelled? Eric? Going?
No, I think I'm good. Thank you.
Oh, you're good. All right. Okay. Benga, can I give you literally one sentence to close off? One sentence.
Okay, one sentence to close up. I would say determining or the ways to go about cross-border transfer in your company, if it's a multinational, any company for that matter, it's a function of strategy, right? You have to be strategic about it. You have to be able to consolidate for the most part and understand the requirements of the law of where the data is coming from. And don't forget what I said at the beginning. The laws of where the data is coming from is much more important than where it is going. With that, I'll close. Can you hear me?
Yeah, we can hear you.
Okay, so that's my presentation, guys. Really appreciate the chance and opportunity to actually speak to you guys. I think African professionals in privacy, I think we should do more of this. It's really enlightening to see everybody on air and, you know, talking to privacy professionals. It's amazing. So good job.
Thanks so much. Great time and great insights.
Okay, have a good one, guys.
Thank you very much. Yeah.
Thank you.
I think we lost the Show. I think she's not here anymore.
The moderator is gone.
I don't know what happened, but we are rounding off, and we hope to see you tomorrow, same time, 4 p.m. West African time, and we promise to have something as exciting as we did today. Thank you very much, and have a good evening.
Have a good evening.
Thank you. We'll see you tomorrow.
Good discussion. Thanks, guys.
Thank you, everyone.
Thank you, everyone.
Have you guys closed? Oh no.
We lost you. You are there.
We're waiting for you.
We're waiting for you.
Please, the floor is yours. The floor is yours, please.
Sorry, you haven't shared the slides.
No,
we will share the slides.
later.
We will share the slides. Don't worry. Guys, without wasting a lot more time, apologies for internet disturbing me. I think we've heard a lot from our instructors today. There are very esteemed speakers and professionals. Thank you, Dr. Mugambi. Thank you, Olamide. Thank you, Gbenga. I think for me, what I've learned the most is that it's important to understand the basics of data privacy and protection so that we can actually be successful in our careers and in understanding what needs to be done. So that was a powerful session today, but I believe tomorrow is equally powerful. We have Harry Boyer on cybersecurity essentials for data privacy. We have Amaka Ibeji on AI, big data, and privacy implications. Last but not least, we have Winnie Ngige on biometric data collection and consent. That is all from us today. Please interact and follow Privacy Hub Africa in full on LinkedIn, as well as TechForGood Initiative. TechForGood is one word, initiative another word, also on LinkedIn or other social media platforms. Please give us feedback on how you found today's session. And yes, there was not enough time just for me alone. I don't know about you, but please follow us. The recordings will be made available on the PHA YouTube channel and possibly on other channels that we found suitable. You'll find me on LinkedIn as well. You'll find me following Privacy Hub Africa. I am the 19th fellow for TechForGood Initiative as well. Thank you, everybody. Goodbye and good night.
Thank you very much.
Thank you very much. Great job.